I want you to look at this map right here on the screen. This may become our reality if the Supreme Court does what it looks like they are planning to do. This may be one of the most important civil rights cases of our time. And it looks like the Supreme Court is poised to gut a major protection in the Voting Rights Act. And I want to talk about it. What happens in the Louisiana redistricting case could decide whether or not black voters anywhere in America can still use Section 2 to stop the quiet, sinister, but not so subtle erasure of black political power. Watch this.
So this is what the party pickups would be for congressional districts. Republicans, 5. Missouri, 1. North Carolina, 1. Ohio, 2 or 3. Indiana, 1 or 2. Florida, still discussion down there, but that could be another gold mine for them if they tipped it even further their way. Kansas, 1. New Hampshire, 1. And Nebraska. Democrats, Utah, California, Maryland. Look at this. If you offset California and Texas, Missouri and Utah, North Carolina and Maryland, everything left over is an advantage to the Republicans. And don't forget, the Supreme Court is considering what could really be the end of the Voting Rights Act, which would protect minority groups. So you don't have a state that's half black, for example, that elects only one congressional member and everybody else goes to the Republicans that would represent that population in some ways. So if that is gutted, Democrats could lose 19 seats. This would be a huge amount. But this is also a measure of how much the White House is concerned about this, because Donald Trump knows if the Democrats get the House again, there could be new investigations just like last time. There could be a new impeachment. There could be a lot of impediment to these plans that right now the Republicans in the House and Senate are letting run like a freight train.
This is the Dollemore Daily. I'm guest host Garrison Hayes, and I need you to be paying attention to this case. I'm going to spend some time with this case, breaking it down for you, kind of talking a little bit about what's at stake and what's happening in the case. But if you stick around, at the end of this video, I'll tell you what I think needs to happen next, how I think concerned voters can respond to this, what concerned voters can say to their representatives and candidates and the like. So make sure you stick around for that. Okay, let's get into this. So the Supreme Court heard oral arguments for Louisiana versus Calais, which challenges Louisiana's 2024 congressional maps. This map added a second majority black district to the state after courts found that the prior map likely intentionally diluted black voting power under Section 2 of the Voting Rights Act. We are in the weeds, but just know that this is important. There was clear discrimination. The courts went through a rigorous analysis and found that the maps broke the law. And then a group of self-described non-African American voters led by a white man named Philip Calais argued that these maps are racist against non-black people and violate the Equal Protection Clause. If you've ever played Uno, they basically did like an Uno reverse card, like in the middle of the game, like, boom, you said that these are racist. Well, you're the real racist. I know you are, but what am I? Kind of thing, like that's the play. And so the Supreme Court took the case, even though a nearly identical case had been decided less than 2 years ago. And so I want you to listen to what Associate Justice Ketanji Brown Jackson, who I got the sense was exhausted, very exhausted and confused by the circular arguments being made in court yesterday. I want you to listen to what she had to say here.
I guess I'm thinking of it, of the fact that remedial action absent discriminatory intent is really not a new idea in the civil rights laws. And my kind of paradigmatic example of this is something like the ADA. Congress passed the Americans with Disabilities Act against the backdrop of a world that was generally not accessible to people with disabilities. And so it was discriminatory in effect because these folks were not able to access these buildings. And it didn't matter whether the person who built the building or the person who owned the building intended for them to be exclusionary. That's irrelevant. Congress said the facilities have to be made equally open to people with disabilities if readily possible. I guess I don't understand why that's not what's happening here. The idea in Section 2 is that we are responding to current day manifestations of past and present decisions that disadvantage minorities and make it so that they don't have equal access to the voting system, right? They're disabled. In fact, we use the word disable in Milligan. We say that's a way in which you see that these processes are not equally open.
She's effectively responding to the question, what counts as racism in this court? And underneath that is this assumption that in order for racism to count, it has to be intentional and deliberate. But what I hear her saying here is that if the outcome is verifiably racist, if the map splits communities so that Black voters can't elect their candidate of choice under Section 2's results test, that matters. It means that they've broken the law. That's why we have these rigorous tests to look at the size and compactness of a community, the political cohesion of a group, whether or not the majority usually defeats the minority's choice. All of that stuff is taken into account in a very sophisticated way. It's all taken into consideration. But the people who want to completely gut the VRA, the Voting Rights Act, are hyper-focused on one word: intent. Did some big bad guy in a KKK hood say, let's keep the Black people suppressed? Let's keep them down, keep them under the thumb. That's what they're looking for. That kind of smoking gun, that kind of red flag. And that brings me to what I think is a completely shameful reinterpretation of the Equal Protection Clause by the Supreme Court. If you watched the affirmative action decision, you saw that the court is more concerned about the way remedying racism could potentially disprivilege white people than it is about the fact, the very present fact of discrimination against Black folks. That's essentially what they're saying. They're saying that the fact of discrimination, the weakening of Black political power, the dilution of Black voting representation, those things are real and present. And they're responding to those things by saying, yeah, maybe, but we've got to protect the white folks against the way you are trying to fix the discrimination against the Black folks, which is kind of crazy, right? It's a little crazy. And I think I can already kind of hear you, maybe not you, but someone saying, right, you two wrongs don't make a right. Like, how you can't discriminate against one group of people just because that group of people discriminated against the other group of people, right? Like, you can't discriminate against white folks because white people discriminated against Black folks. But I want to look at the numbers. I want to dig into the numbers here. About 33% of Louisiana is Black. That's a third. This case is over their desire to go from one of the 6 congressional districts in the state being Black majority, being representative, being districts that guarantee equal voting protection. They're trying to move from 1 of 6 to 2 of 6. This isn't a thing where they're trying to have 4 out of the 6 congressional districts in the state be Black majority. No, they're actually just trying to move to parity. They're trying to move it from 1 of 6 to 2 of 6. And they're being sued for it. This isn't about taking advantage of white people, but the question is whether or not the same can be said in the other direction. You cannot look at the way the SCOTUS, the Supreme Court, is reinterpreting equal protection and not come to the conclusion that white people are more privileged. Their concerns are taken more seriously than non-white people at a judicial level. Time and again, Associate Justice Ketanji Brown Jackson asked the question, wasn't the starting point of all of this years ago, wasn't the starting point of this litigation discrimination? Didn't we look at the details years ago? Didn't we study the facts? And didn't we come to the conclusion that Black people were being discriminated against in Louisiana? Why isn't remedying that discrimination, she's asking, a compelling state interest? I want you to listen to her exchange with Louisiana's attorney here.
I don't understand why your answer to Justice Kagan's question about is this a compelling state interest is no. The answer is obviously yes, that you have an interest in remedying the effects of racial discrimination that we identify using this tool. Whether you go too far in your remedy is another issue, right?
Your Honor, I think step zero in all of these cases, it was certainly step zero in the Robinson litigation, is the plaintiffs came in and said, we want another majority black district.
I thought they came in and said, we are not receiving equal electoral opportunity because our votes are being diluted.
Which is the same way of saying we deserve a second
No,
majority
it's not,
black district.
because again, just trust me on this, the second electoral or second district is a remedy that one could offer for a problem that we've identified. And the whole Robinson litigation was about identifying the problem. Is this really happening? In many, many Section 2 cases, the court says, you're wrong, you're fine. There is not an electoral opportunity being denied to you, go away. In this case, the court said, I see. I'm looking at the factors. I appreciate what you're saying. You've proven that we have this problem. And so the next question is, how do we go about remedying it?
So there you have it. There it is. I'm getting to the point where I think more and more people are going to be calling for the expansion of the courts. I think they're going to be saying expand the courts. I think folks are going to be asking 2028 candidates if expanding the court is a part of their plan if they're elected. You know, this institution has become increasingly hostile toward democracy. It is consistently limiting the rights of minority groups, of women, consistently undermining the power of Congress, reinterpreting laws. I think that's going to happen. So anyway, tell me what you think. Should pro-democracy candidates focus on expanding the courts to retry these cases or protect against a right-wing interpretation of the law in future cases? That's the question. Let me know what you think down in the comments. I'm Garrison Hayes. I'm guest hosting for Jesse Dollemore this week for a few days. Make sure you like this video and subscribe if you aren't already subscribed. I'd also love it if you came over and subscribed to my channel at Garrison Hayes. There's definitely a link below as well. Thank you all, as always, for such a warm embrace, warm welcome to the Dollemore Daily. I really do appreciate all of the kind words that I see in the comments. That's very, very nice of you. If you missed yesterday's videos, there's some great videos. Yesterday, I talked about Letitia James and what's happening with her, another kind of court case that we should keep an eye on. So go back and check that stuff out. Thanks, as always, for watching. I'll see you next time. Peace.